Okay, request. Let's do a screenshot. So we're going to smile. And treasurer, if you can, it'd be awesome if you could be in it too. So you would have to turn on your camera and then we can post it. Yeah. How's that looking? Becky's going to do it. I don't see the treasurer though, so I'm hoping she does.
I see the treasurer. I see all of you. Okay, I'm doing it right now. So everybody smile. One more. Okay, thank you.
And wait, but Brett, do you want one with your slide instead of this slide?
Oh, sure. Yes. Here.
There we go.
Okay, wait. Okay, now. Thank you.
Thank you. Thanks. Oh, we can't hear you, John.
How about now?
Perfect. Awesome.
All right, super. Want to welcome everyone to our final webinar in our series. I think we've had a lot of great presenters. I want to thank everyone again for participating. This was new to us. We're really honored to have received the grant from the National Association of State Treasurers and to have the funding for all that we're doing here provided primarily by Wells Fargo Bank. They really made all this possible. And I also really can't understate the importance of Dr. Jennifer Davidson in this entire process. Honestly, this could not have been done without her. She absolutely integral in making this happen. Thank you, Jennifer, for what you did here, for what you do for financial literacy across the state of Nebraska. We've received a lot of positive feedback. I think we've gotten some suggestions for financial literacy 102, basically, for a deeper dive into what we've already discussed. And we're currently sort of evaluating our options going forward, but we sure want to continue to provide these sorts of resources across the state, especially if you folks found it to be valuable and useful. We want to try and do whatever we can to provide this free of charge for everybody, and for you to all make the most out of it. So again, thank you very much for being here, and I will turn it over to Dr. Davidson to introduce Brent.
Awesome. Thank you so much. I agree. It's so bittersweet that it's our last sessions together. It's been wonderful. So thank you, Treasurer. Thank you, everyone that's been participating. You've just been wonderful with your questions. It's been great. So just the housekeeping, as we've been saying every single week, let's continue to do both the Q&A and the chat. So Q&A for questions to come to any of us or Brett, and then the chat for just chatting with each other, which is perfectly wonderful. Continue to do that. As usual, stay to the end. We'll announce our 5 lucky Amazon gift winners. And then tonight, so tonight we're talking about the ability to plan for what happens to our assets and our children if and when we pass away. It's not something we like to think about, but it's so much better to think about it and to document it. So tonight, estate planning, and I'm grateful to have Brett Ebert as our speaker. She's a partner at Ball, Loudon, Ebert, and Brostrom. She's one of my board members at the Nebraska Council on Economic Education, and she is my estate planning attorney. So I have personal knowledge about her awesomeness. Brett, I'm so grateful for you to be here and share your expertise with us tonight. I really, really appreciate it. So with that, I'm going to turn it over to you.
Great. So hopefully you can hear me okay. Let me know if you can't, Jennifer. As Jennifer said, my name is Brett Ebert. I am an estate planning attorney with Ball, Loudon, Ebert, and Brostrom. We are a boutique estate and business planning law firm. So the only type of law that we do is estate planning, estate administration, and then business work. So first, let's start with a poll. And Jennifer, Dr. Davidson, I think you are going to.
Okay, I'm launching that first one. And the question is, do you feel anxious about what would happen if you were to suddenly pass away? And it takes a minute. So there's 530 people on here. So it takes a minute for all their answers to roll in. All right, 5, 4, 3, 2, 1. I'm going to end the polling and let me show you the results. So here you go. Can you see them? Yeah, so 48%, yes, it makes you anxious. Yes, it does. It makes us anxious. No, it doesn't. And then 10%, which, a lot of people really do fall in. I don't want to think about that, which is where we are and why we're talking about this tonight. I'll turn that back over to you.
Absolutely. Let me close this. Okay, so the first thing I always like to point out to clients, or even when I'm doing these types of presentations, is that if you don't have an estate plan, the true news is that you actually do have an estate plan. However, the state of Nebraska has written it for you. It's called intestate succession. So we have laws that deal with what happens to people's property if they die without a will. So here are just some examples. One I always like to highlight is that if you are married and you and your spouse have children, if you die without an estate plan in place, your spouse gets the first 100,000 plus half of whatever is in your name alone, and your children get the other half. It doesn't all automatically go to your surviving spouse. Similarly, if you look at the third bullet point there, if you are married and you don't have children, your spouse would get the first 100,000 plus half, and then your parents would actually get half. of whatever is in your estate. What's almost never going to happen, and a really common misconception that we hear about or I see in TV shows about not having an estate plan, the state is very
Yeah, Brett, you're frozen. I think we just dropped her. So we'll give her a second to jump back on. I'm going to text her at the same time.
I'm back.
Oh, good. Okay. Awesome.
Sorry. Hopefully that doesn't happen again. So what I was saying is that what's very unlikely to happen is that the state is not going to get your assets. So some people think if you don't have a will, it all goes to the state. That's very unlikely. You would have to have literally no descendants or anybody that we could find. But what is true is that the state writes your estate plan for you. So here are kind of the typical 5 key components of an estate plan. First, you're going to have a last will and testament. You may or may not also have a living trust. We are always going to talk about beneficiary designations. You're going to need a durable power of attorney for finances and a healthcare power of attorney. So all of these components are a really important part of a comprehensive estate plan. So before we get into what some of these documents do, let's start with just a little bit of basic terminology. So one thing we're always looking at is your property what we call probate property or non-probate property? So probate is this old-fashioned process where we actually go to I am so sorry. Can you hear me?
I can hear you. I wonder if it would help if we just turned off your camera. So
Okay.
we have more strength.
Okay, so let's get into probate. So probate, like I was saying, is this really old-fashioned process where we actually get your will admitted to court, and then someone is appointed your personal representative, and then it's administered that way. Non-probate property passes in accordance with beneficiary designations or how that asset is owned. So for example, if you own a house with your spouse as joint tenants with rights of survivorship, at your death, your spouse will get 100% of that house. One thing about non-probate property is that it is still subject to all of the taxes that we're going to be discussing tonight. So again, that probate process is a really kind of old-fashioned process, and here's just kind of some downsides. It can take a lot of time. So a typical probate in the state of Nebraska takes anywhere from 6 months to a year because there's a lot to do. So we have to go out and collect all of the decedent's assets. So the decedent just means the person that's passed away. So we have to go out, figure out where did they have accounts, what property did they own, what debt do they have, and what expenses do we need to get paid. And then once all of that's done, we can distribute the assets to the people that are entitled to them. So now we have another poll question.
All right, so this one is, do you have a written will? Do you already have a will? Let's see where our group stands on this. Okay. 5, 4, 3, 2, 1. I'm going to end the polling and share the results. So our results for our group are 37% say yes, they do, 62% no, they don't, and 1% are saying I'm not sure. So good to know.
So, and I would say that's pretty common. I mean, the statistic we hear is that about 40% of Americans have an estate plan. So about 60% do not.
Okay.
So here is kind of the main document when it comes to your estate plan. This is called your last will and testament. So one of the most important things that this document does is says, where does your stuff go? So who's going to inherit? You know, what age are they going to inherit that property? So this could be your spouse, this could be your children, this could be your next door neighbor, could be anybody. But you get to decide where it goes. Next, it's going to provide what we call a laundry list for personal property. So a laundry list is a document that you can actually create outside of your will that would say where you want your wedding ring to go. Where do you want your grandmother's china to go when you die? So this is the document that we like to use for those household items, family heirlooms, things of that nature. Your last will and testament is also going to name your personal representative or executor. This is the person who is in charge after you die. So this is a pretty big job. This is a decision that we spend a lot of time talking to clients about because you don't want to just necessarily name your oldest child as personal representative unless your oldest child is pretty organized, fairly good with financial matters, and all your kids get along. Because if you don't have the right person in charge, that probate process can go really poorly. This is also where if you have any minor children, we're going to name a guardian of those minor children in the event you would pass away before they turn 19. So a lot of people have kind of heard of a trust. Most people don't know exactly what it is. I have a lot of clients that come in and say, I need a trust. And I said, well, why do you think that? And because Susie Orman said that I did. So what is a trust? There are actually a couple of different types of trusts. The first is called a testamentary trust. This just means it's a trust created within a last will and testament. This is a really common tool that we might use for a young couple who has minor children. We just do simple wills, but we build in a trust for those minor children in the event the parents would pass away prior to those kids reaching a certain age. A living trust is a trust that you would actually create while you're alive, hence the name living trust, and actually put your assets into it while you're alive. The main benefit of using a living trust is that probate avoidance. So this allows you to avoid the probate process when you die. And when I say you, I really mean your children, because you unfortunately won't be here to enjoy avoiding probate, but your kids or your beneficiaries would. So avoiding probate can certainly save on attorney's fees and court costs. A really other important benefit of a living trust is that while you're alive, this can actually help with asset management. So if you were to become incapacitated, which just means you can't manage your own affairs, maybe because of an illness or dementia, something like that, if you have a living trust, your successor trustee could actually step in and manage your assets using that trust. So trust can be either revocable or irrevocable. A revocable trust just means one that can be changed, and irrevocable means it can't be changed. So one of the most important decisions you're going to make about your trust is who's going to be the trustee after you're gone. So similar to a personal representative, the trustee is the person that's in charge. So they're going to have to figure out what you own. Hopefully it's all in that trust. They're going to have to make sure all your final expenses are paid, make sure all your creditors are paid, and then distribute the assets to your beneficiaries. With trust, I always like to kind of recommend that people proceed with caution. Trust-based estate planning is not really a do-it-yourself process. This isn't really something you can buy on the internet because there's so many nuances with getting it set up correctly. So we just don't want to see people fall prey to some of these kind of like sales schemes with trust. And because it may cost more later to actually fix something. So Similarly, you know, we get asked a lot why can't I just go on LegalZoom? You know, that might work out totally fine. And we used to say that having something was better than having nothing at all. But actually, if you have something that's wrong, it often costs more money to clean that up than if you didn't have anything at all. So I mentioned that beneficiary designations are an important part of the estate planning process. This is really where the rubber hits the road. So the way that your assets are owned or what your beneficiary designations are is really what controls what happens with your estate plan. So if you own something with another person as joint tenants with rights of survivorship, that means that as one of those joint tenants dies, the surviving tenants own that entire property. This is usually how spouses own real estate together. Another type of ownership is what we call tenants in common. This means that each owner owns an undivided portion of that property. So if you and your spouse owned your house as tenants in common, you would each own 1/2 of your home. And then at the death of one of you, your 1/2 wouldn't automatically transfer to the other owner. We'd have to get it there using your will or trust. So we typically do not recommend owning property this way with spouses. Sometimes we'll see siblings owning real estate this way, especially if it's something that they've inherited. Payable on death and transfer on death designations are very similar to beneficiary designations. This just names a person or trust to get that asset at your death. So this is a really common thing that we might see on an individual retirement account. You're likely going to put beneficiary designations on those types of accounts. Same thing with bank accounts. Investment accounts are typically, we're going to work with you to make sure that, you know, your payable on death or transfer on death beneficiary designations all line up with your estate plan. Just a quick example of where this can go really wrong. This is a really common scenario. A person might have a will that says, leave everything equally to my 3 children. But then for whatever reason, when they were setting up an investment account, they only put 2 of their children on as beneficiaries. So that beneficiary designation overrides whatever is in that person's estate plan. So that investment account would only get split between the 2 children listed as beneficiaries, not between all 3 of the children, which is what the decedent's will had said. We generally recommend not owning property as joint tenants or tenants in common with your children. If you start putting your children on your assets, whether it's your house, your bank accounts, it becomes their property. So if your children have any creditor issues, if they get divorced, anything like that, your property could become subject to their creditors. So a durable power of attorney
I think we lost her again.
I'm back.
Okay, well, at least you come back quick.
I know. Oh my gosh, this is terrible. Okay.
I do have a lot of questions. Do you want to take a couple?
Sure.
There's quite a few. So yeah, let's get through a couple of them. So I think you kind of covered this already. So if it's not created with an attorney, is it considered legal?
And I can't hear you. Sorry.
Okay, one more time. So if your documents are not created with an attorney, are they legal?
So whether or not they're legal doesn't really depend on who drafted them. It's really, are they executed correctly in the state that you live in? So in Nebraska, for a will to be considered to be validly executed, it must be signed in the presence of a notary and 2 disinterested witnesses. So disinterested witnesses means people who are not named in the documents.
Okay, awesome. That covers actually another one. Does it have to be notarized? Is a will that was made in another state and then you moved to Nebraska, is that valid?
Likely, yes. So because it was valid in the other state when you signed it, it would be valid in Nebraska. However, we often recommend that people, if they move to Nebraska, just go meet with an estate planner in the state that you've moved to make sure there's nothing quirky or state specific that you might need to update in your documents.
Does it change who gets your assets in the event you don't have a will if you're single?
So if you're single and you don't have a will, the intestate laws still apply. It would be your parents, if you have any surviving parents. If you don't have surviving parents, then it would be your siblings or any of their children, like nieces and nephews.
Awesome. Maybe two more. Do living trusts protect assets from creditors?
Great question. No, not in the state of Nebraska. So
Okay.
if it's a trust that you create and you put your assets into it, it is still available for your creditors.
Is a laundry list legally binding if it's not notarized?
Yes. So one of the great things about laundry lists is that they only have to be signed and dated. So oftentimes people will do their estate plan and then their laundry list is kind of a continuous document that they're updating. And so like when I meet with clients, I give them 3 or 4 blank laundry lists so that they can update them and redo them as they wish.
Okay, awesome. I think that's good for now.
Okay.
Thank you.
Yeah. Hopefully I stay on for the rest of it, or at least get back in quickly if I get kicked out. So the durable power of attorney is a really important document to have while you're alive. So this document would give somebody else the ability to do anything with your finances that you can do as long as you're alive. So as soon as someone dies, this document is no good anymore. The person that we name in there is your agent. They are not an owner of your assets. We always tell people only name someone that you have absolute trust in, because most durable power of attorney documents are written to be valid as soon as you sign them. So you don't have to be incapacitated before somebody else can start acting as your agent. And this is an important reason, because people can sometimes have periods of incapacity that we don't like to make these contingent on whether or not you have capacity. So that's why it's really, really important to only name someone you trust implicitly. If you want your agent to be able to make gifts of your money, so to give away any of your assets, that power has to be specifically listed in the power of attorney document. Sometimes I'll be meeting with children who are named as mom's agent, and they'll bring in all of mom's documents. Mom's still alive, but she's lost capacity. And they say, okay, well, we've been, making gifts. And I'll look at the power of attorney and say, you actually don't have authority to do that. It has to specifically say my POA can make gifts in order for that to be valid. That trips people up pretty frequently. So a similar document is called a healthcare directive. This is also a power of attorney for your medical. So this is giving someone else the ability to make medical decisions on your behalf. This one, you do have to be incapacitated before somebody else can start making medical decisions for you. Our standard document includes a living will or advance directive, which most people want it to say not to take extreme measures if their condition cannot be improved. A really important thing that should be in every healthcare directive is a HIPAA privacy release, because otherwise you run the risk that the provider won't talk to the person that you've named. So next we have estate planning tax considerations. But quickly, Jen, do we want to stop for any more questions about estate planning before we move into taxes?
Sure, there are a lot again.
Okay.
So I don't know if you want to answer this, but I know you know this off the top of your head. So how much does setting up an estate cost? So are you willing to share?
Sure. So I would say generally, when you go to meet with an estate planning attorney or before you do, that is definitely an appropriate question to ask, because most estate planners do enough of these that they should be able to give you a pretty accurate estimate of what it's going to cost. I personally do estate planning work on a flat fee basis. So for most simple estate plans, which would be wills, powers of attorney, healthcare directives, so no living trust, just a will, that's an $800 flat fee. For a trust-based estate plan, which would include that living trust, wills, financial and healthcare power of attorneys, is a $1,500 flat fee. So that's probably, honestly, because we have a statewide audience here, those numbers make sense in Lincoln and Omaha. I don't know if those numbers make sense in Scottsbluff. So definitely, reach out to your attorney that you're going to work with and have them give you an estimate.
Perfect. Thank you so much.
Yeah.
Do trusts and wills need to be filed with a court?
Not while you're alive. And we almost never file a trust. That rarely becomes part of a court record unless there's a lawsuit involved, which means something's gone wrong. But your will would get filed with the court at your death as part of that probate process, but not before.
If I have a joint checking account and I die, does the money go to the other person automatically?
Yes.
Should I also put my executor on my retirement in case my spouse passes before me?
No, your executor, you don't want them listed as a beneficiary, which means they just get the money. It doesn't mean they have to administer the money. So your executor is not always the same person as your beneficiaries or where you want the money to go. So the executor is really just a job for somebody to do. It is not who gets the money.
Awesome. This is kind of an interesting question. Can a laundry list be done with video instead of paper?
Digitally, is that what you said?
Yeah, sorry, with video, yes.
Oh, video. So technically it's a written list outside of your documents. So it needs to be written
Okay.
on paper.
Is it better to have two different people, one for financial and one for medical power of attorney?
Sometimes that's why we do them as separate documents. You might have one child who'd be great on the finance piece and one person who would be great on the medical. Sometimes it's the same, sometimes it's different.
What does it mean to be incapacitated?
That means you are deemed to no longer be able to manage your own affairs. So sometimes a doctor might deem someone as not having capacity, but often, it becomes pretty obvious.
How often should a will be updated?
Great question. So I always recommend that people at least look at their own documents every year or so. Just read them over, make sure that they do what you think that they do. Most of the time people think their documents say one thing, but they actually say something else. So I think you should look at your documents every year or so. Certainly if there's a big life event, if there's an unexpected death in the family, if your financial situation changes, those are definitely times when you want to actually meet with an attorney to update those documents. But I would say most people do probably 3 sets of estate plans in their lifetime. When they're young and have kids, that's usually the first time we do it. And then maybe as they are kind of nearing retirement is another time that we might update people's estate plans, and then typically one more time before they pass away.
Okay, one more and then we'll get back to the presentation.
Okay.
Should you name a backup executor? So thinking that if a person I appoint would pass away with me in an accident or something along those lines.
Absolutely. And in fact, I usually ask for at least 1, if not 2 backups in all of these roles. Another consideration that I always have people think about is you could name an individual as your executor or trustee, or you could also name what we call a corporate fiduciary. So that would be a corporate trust company. This would, our law firm, all of my partners, we are big fans of corporate fiduciaries, even if they're only named after 2 or 3 people in your documents, for one really important reason, that they never die. So we know that if something crazy happened and we don't have any individuals, we would at least have this corporate fiduciary. So this would be like a bank or a trust company. They also are really good at this job. Being a personal representative or being a trustee, some of you probably maybe have had to do this. It is a burden. It is a really hard job, especially if you're grieving a death. So naming a corporate fiduciary just takes all of the family dynamics out of it. And in our experience, things tend to go a lot smoother.
Awesome. There's a
Great.
lot more, but let's keep going, and then we'll come back if we have time.
Okay, very good. I'll go through taxes briefly because nobody wants to hear about taxes too much. So there are really 3 main taxes that need to be considered when you're doing estate planning: gift taxes, federal estate taxes, and Nebraska inheritance taxes. So that's always our goal with taxes: reduce, eliminate, or defer. So this gift tax slide, really just pay attention to that first bullet point. That's the most important thing I'd want you to remember, because most people have some concept of this. Most people know you can give a certain amount away each year and not have to pay taxes on it. What that is what we call the present interest annual exclusion amount. It's currently $15,000. So each one of you could give each other $15,000 per person per year and not have to worry about any gift tax consequences. So that means a husband and wife can give one person $30,000 per year. So most people have a concept of that. I will be happy to answer questions about gifting above $15,000, but for the sake of time, I'll just keep going. Federal estate taxes is something that we are really paying attention to a lot right now, because Congress is probably going to be changing all these laws. But currently, each person who dies in the United States gets an $11.7 million exemption from the federal estate tax. So for the majority of my clients and the people that we work with, we are not worrying about federal estate taxes. Certainly, if people have net worth where this is a concern, you definitely need to be working with an estate planner. We're going to skip generation skipping taxes. This Nebraska inheritance tax, I did want to spend some time on, because this really affects most of the estate administration that I do. So in the state of Nebraska, we have a very, I don't want to say harsh, but kind of old-fashioned inheritance tax system, where we look at the relationship between the person who died and the person that's inheriting the property to determine how much tax there's going to be. So spouses pay no tax, charities pay no tax, but if somebody is inheriting from you and they're what we call a class 1 beneficiary, so this would be close relatives, children, grandchildren, brothers and sisters, they each get the first $40,000 tax-free, and then they're paying a 1% tax on the excess. So very quickly, the Nebraska inheritance tax will be due in an estate because we only get a $40,000 exemption. Class 2 beneficiaries, this would be remote relatives, nieces and nephews, aunts and uncles, cousins. They only get the first $15,000 inheritance tax-free, and then they pay a 13% tax. And then class 3 beneficiaries are non-relatives. So anybody who inherits from you who's not related to you, they get the first $10,000 tax-free, and then they pay an 18% Nebraska inheritance tax. This is assessed at the county level. So if you live in Madison County and you die, the Madison County Treasurer is getting a check for your Nebraska inheritance taxes. So here's the important deadlines with taxes, and I wanted to point it out because the Nebraska one mostly. This is due 12 months from somebody's date of death. And what's really important about this tax is that a lien automatically attaches to real estate when somebody dies. So if someone dies in the state of Nebraska, there's a lien on that property, which means it cannot be bought or, sold with clear title until this inheritance tax issue is dealt with. So I'd like to be able to make estate planning simpler, but we don't know when you're going to die or lose capacity. We don't know what you're going to own. We don't know the value of what you're going to own. We don't know what the tax and other applicable laws will be. We don't know if your primary beneficiaries will survive you. We don't know your order of death. And most clients are unwilling to commit to dying first to make our jobs a little bit easier. So we just kind of have to plan for every scenario. So estate planning, like I mentioned, really not a do-it-yourself project. It's really important that you seek competent professional help with your estate plan. And it should be a team approach. So your estate planning process should include your CPA, your trustee, financial advisor if you have one, your insurance agent, and your attorney. I think we've got a little time for questions.
Awesome, because there's a lot of them. So
Okay.
I'm just going to continue to pepper you. Okay.
I'll put my contact information up too, so people can grab it if they want.
Wonderful. And I'll send them the slides tomorrow as well. So for Nebraska inheritance breakdown, where would stepchildren fall?
Great question. So stepchildren, we typically are able to get considered children. So they would be those class 1 beneficiaries. So 40,000 tax-free and then a 1% tax rate.
And how about in-laws, close relatives, distant relatives?
So it depends on who they're married to. So if it's your brother-in-law, he would be considered a close relative. If it's someone married to your nephew, they would be considered a remote relative.
Is there any point a probate wouldn't be required?
Yes, if somebody died and all of their assets were in a trust or had a co-owner or beneficiary designations on them. So the only assets that are subject to probate are those that are in that person's name alone that have no beneficiary designations.
Okay.
But just remember, just because there's no probate doesn't mean that inheritance tax isn't due. So somebody has to pay the taxes.
Okay. The only thing that are certain are what? Change in taxes, death in
Yep,
taxes?
death and taxes.
Okay. What if the trustee doesn't want to execute the will? They don't want to be the executor after a death. Then what
So
happens?
if they don't want to, they can decline to serve. We can't force anybody to do this job. And then we have a procedure for getting somebody else named. If they do accept the job and they just decide they don't like the will, they don't want to do what the will says, then they are breaching their fiduciary duty and they will get sued, or they could be sued.
Okay. So is this something you should have a conversation with the executor?
It depends on who you're naming and how they're related to you. Certainly if, I don't think it's a bad thing. I do typically recommend people keep their estate plans private, even from their children most of the time, because you can change your mind. And where we see people fighting after mom and dad are gone or after somebody dies is when expectations are one thing and reality is different. And so sometimes we do have family meetings and everybody knows what's going to happen. Sometimes mom and dad never tell and they don't find out till they're gone.
Okay. Would my spouse automatically become the guardian of our children at my passing, or do I need to specify my spouse as the children's guardian in the will?
So if your children have a legal guardian, that will be their legal guardian. So your spouse would be their guardian automatically when you die. Similarly, if you are divorced or not married to your child's other parent, assuming they still have parental rights, they would become the guardian unless somebody fought them for it.
Okay. When it comes to people in charge of your medical, if you do not appoint someone while capable and alive, will it automatically be your spouse, or can your parents make those decisions?
So we have a relatively new healthcare surrogacy law in Nebraska that has an order of priority, and your spouse is going to be first. And then it kind of goes to other, like children, and then sort of other family members. I don't like to rely on that default law though. So that's why I strongly recommend healthcare directives, because if people start fighting and you don't have this document in place, likely the hospital is going to make somebody get appointed your legal guardian through the court system. And that's something you'd want to avoid. So if you're only going to do 2 parts of an estate plan, do the financial and healthcare power of attorney. To me, those are the most important.
Okay. Here's an interesting question too. What is your advice for same-sex unmarried partners as far as estate planning? Can the other family members take control of the deceased property, et cetera, from the surviving partner?
So if they don't have an estate plan, Nebraska doesn't recognize common law marriages. So this is the same for any non-married couple. In Nebraska, you would not be part of the intestate laws. So it would go to your partner's parents or brothers and sisters. So that's why you definitely should have an estate plan. But if you're not married, you're going to be hit with an 18% inheritance tax.
Okay, good to know. Are assets and financial accounts with beneficiaries designated subject to estate taxes?
Yes.
So
The only thing that's not, so in Nebraska, the only asset that would not be subject to the Nebraska inheritance tax would be life insurance that's payable to a named beneficiary. So a named beneficiary could be a person, it could also be a trust. But if you don't have a beneficiary on life insurance, or if the beneficiary is my estate, then it will be subject to the Nebraska inheritance tax.
okay. Okay, here's a good one too. If 3 sisters inherit from a deceased brother and then one of those sisters dies, do her kids get her portion, or then what happens?
So it depends on when she dies. And I've had this happen twice in the last year. So if she died before brother, then yes, her share would go to her kids. If she died after the brother, so say during the probate process, if he died intestate, as long as she survived him by 5 days, her share would go according to her own estate plan. So her own estate plan might say, leave everything to my kids. It might say, leave everything to my neighbor. Most documents I draft say that people have to survive you by at least 2 months before it would go according to their own estate plan, to preserve your intent a little bit longer.
Okay, here's a tricky question too. Is it a bad idea to have both of your children as co-trustees, as they are also both beneficiaries?
The answer is it depends. Do they get along? Do they see eye to eye on things? If they don't, making them co-trustees will not make them get along. It will make things extremely worse. So it really depends on their relationship. I typically generally don't like co-trustees, especially 2, because now we have a committee of 2 people, and if they can't get along, we end up with trouble.
Yeah, it's more difficult to make decisions for sure.
Yes.
Okay, so does the trust prevent taxes then?
No, it does not.
Okay. How about, are there pros and cons to internet wills?
Oh, okay. So a pro would be that it's probably cheaper than, meeting with an attorney. The con, so when you say internet will, like if you're talking about like just Googling will and printing off a form, I would strongly encourage against that. Every one of those I've ever seen or tried to administer has been wrong and has cost way more money to try and fix than what the person would have paid to do it with an attorney. Now, something like a LegalZoom or an online, estate planning law firm where you can at least put in your information and it's a little bit customized, it's probably like 50-50 if it's going to be fine. It very well could be. The important thing I always would strongly have you look at is how does it need to be executed, because that's where things go awry the most when people try to do it themselves. They might not have it be witnessed properly or use witnesses who are related. And then on the probate side, it costs way more money to try and probate an estate plan like that. But what you're also missing out on is the counsel from the attorney asking you to think through questions like, you want to name both of your kids as co-trustees? Well, tell me about your kids. Do they get along? Here's why that may or may not be a good idea. So,
excellent advice. 3 good ones in a row. Is it a good idea to use an employer's offer to set up a free living will?
So I think that's fine. Depends on, are they just printing off a form and giving it to you to use, or are they giving you the opportunities to sit down with somebody and get to kind of talk through the decisions that you're making?
Okay, good things to think about. When someone contests your will because they don't like what they got, what they didn't get, can that override your wishes?
It depends. So will contests are actually pretty difficult to win because a validly executed will can only be thrown out if the person who made it was under undue influence when they created it, if they didn't have testamentary capacity to create it, or if it was just a result of fraud. So it's actually pretty hard to prove all of those things. But it's potentially, a lot of times then we would default back to the person's previous will if we're able to say that the most recent one was done incorrectly or fraudulently.
Okay, but pretty unlikely. That's what
pretty unlikely, but estate litigation, which are lawsuits around people's wills and trusts, is happening more and more frequently. So it's a growing area of law. And so that's why if somebody's meeting with me and they're making a drastic change to their estate plan, like cutting out a child, and they're, maybe I have questions about their capacity, I'm going to have them get evaluated by a doctor before I have them sign an estate plan document like that. If one of their children brings them to the appointment and says, Mom wants to change her will to take out my brother, I'm going to say, okay, you can leave the room now, and I'm going to ask Mom what she really wants. So we're trying to, as lawyers, we know what to look for. So we're not going to write a will for someone that we think doesn't have capacity.
Okay, good to know.
Yeah.
What happens if I marry and my family has a trust? Will my spouse have any access to the trust?
It depends on the terms of that trust, but I would say likely no. Spouses are not included automatically. So if somebody wanted to leave money to their son-in-law, if their daughter didn't survive them, that would take special language. So unlikely, no.
Okay. If there's no will and only a laundry list, it still only needs to be signed and dated. Is that right?
You cannot do a laundry list unless you've done a will. So your will has to reference the laundry list in order to make it valid.
Okay, awesome.
But there is a thing, I saw a question earlier about handwritten wills. So it's kind of similar, I think. We do in Nebraska have a provision for what we call holographic wills, which is a handwritten will. These are valid, but they literally have to be handwritten. If you type it up and print it out and sign it, that is not a valid holographic will. So in order for it to be a valid holographic will, it has to be in your handwriting and signed and dated by you.
Okay, good to know. One last question, and then we have a lot of housekeeping items to talk about for our last session. Can you list a nonprofit as a beneficiary? And if so, what's the process? Do you just need their tax ID number, or how do you do that?
Great question. So yes, you can absolutely list a nonprofit as a beneficiary or as somebody in your will to receive money. Typically, I don't include tax ID numbers. I will just name the nonprofit and the city that they're located in so that we can make sure we identify the correct one. You can also work with that nonprofit and tell them that you've named them in your estate plan if you want to, and get really specific about what you want to use the money for. And I encourage people to do that if they want to.
Awesome. Thank you. All right. Thank you, Brett. Such great information. It really is. Estate planning is complicated. So it's really nice to have somebody like you come and share with us tonight. So thank you for that. All right. I have a list of items to discuss. So if you have questions on any of these, pop them in the chat or the Q&A. I'm looking at both at the moment. So first, there's already been some questions on this. The post-test. It will open as soon as we get the attendance updated for tonight. So it will only show up for those that have they've completed the pretest and attended all 6 of the webinars. Then the post-test will show up for you. So as you've seen in past weeks, it takes us a little bit to get the attendance updated. We have to run a match program, and then there's some that get kicked out, and we do those manually the following day. So it should open. We'll try to get it done tonight so you guys can start taking those tonight. The $100 incentive. So 200 of you will receive the $100 incentive. Just by way of reminder, you have to have completed the pretest, all 6 webinars, and the post-test to be eligible for the 200. I checked the number of people that were still in the running for that, maybe after last week's session, and there were still like 600 of you eligible. So just know that. We will notify all of you. We'll notify people that did not happen to be the randomly selected 200 of the folks that are eligible. And of course, we'll let you know those that are eligible that have that were randomly selected to be one of those 200. So know that the post-test needs to be completed by Sunday, this coming Sunday, which is the 16th, because we're going to pull down all of the data and pull the $200, $100 winners on Monday. So those emails will go out Monday afternoon. Lots and lots of questions on this as well. 2 things. One, we are recording all of these webinars. We're going to package them in a sustainable and more flexible format. So all of the recorded webinars, all of the slides and the handouts will be posted on the same website that we've been utilizing all along. But it's going to take us a little bit to get that done. So I'm projecting midsummer, maybe end of June, to get that completed. I will email everybody though and let everybody know once they're up and ready to go. I also want to show you resources that, we've spent all this time together and we've been focusing on financial wellness. And I want to make sure you guys continue this journey. So on the website we've been using, nebraskafinancialwellness.unl.edu, I want you to see there's this resources tab here, and there's a wealth of information for you to continue on this journey. So there's all kinds of different categories: financial stress, money skills for life. So any of these topics, just dig in here and continue on this journey. So I wanted to make sure you knew about that. I think that is it from me. We're going to name the winners for tonight's 5 $50 Amazon gift cards. So let me stop sharing and go pull those. Let me see, there's questions coming in. Is there anything that I just talked about that you guys have questions on? Yes, you can absolutely share the website with others. Please, please do. Anybody is welcome to this information. It's open and available to the public at this point, especially all those resources. They've been curated by financial education experts, so there's no selling on the website. It's all good information. Yes, if you won one of the $50 winners during the webinars, you are still eligible for the $100. Yes, you are. If you missed any of the sessions, you will not be sent the post-test. The webinars for today, the attendance has not been updated yet. That'll happen later this evening. And you also have to log in to see your personal progress through the webinars. All right, let me see our winners for tonight. Here we go. I have Tyler Probino from Imperial, the city of Imperial. Sherry Brasby from North Platte, Department of Health and Human Services. Patrick Weichert from Lincoln, State of Nebraska Probation. Sheila Bynes, Seward, Nebraska Supreme Court. And Ty Ha from State of Nebraska, Lincoln. So those are our 5 lucky winners from tonight. I will send you those gift cards here momentarily. Congratulations to all of you. And with that, I'm happy to answer any other questions, but I'm going to turn it back over to Nebraska State Treasurer John Moranci to close us out.
Thanks so much. Can you hear me?
Yes, we can hear you.
Thanks so much. Can you hear me? I'm having some technical difficulties, but I just want to say thank you again to everyone for participating. I think this was fantastic. As Dr. Davidson said, we're going to have all of this online and available probably this summer, so people will be able to review all of the information. And I want to thank everyone for participating. Really, this exceeded our wildest expectations. So thank you again. Really appreciate it. And with that, I think that's all I have.
Hey, that's a wrap. Thank you, Treasurer. It's been
Thank you.
great. See you all in 2.0. We'll
That's
send
right.
we'll send out the info.
Great.
All right. Thanks, everyone.